it has been a sheer pleasure to be, able to listen to all these conversations which have been happening before I could join in and before I could get this opportunity to talk. And I'll take forward the dialogue that has already been initiated by Dr. Vijay Lakshmi and Dr. Professor Dadich. Beautiful narrative has been set by both of them. I don't think that there is actually any requirement or anything that we can add to the or to create furtherance in this dialogue, because if we look at the relevance of today and the thoughts that I would be sharing with you about the misuse of dowry laws is going to be in continuation of what has already been narrated. So I'll try and connect the dots so that I don't become too repetitive and it doesn't become too monotonous for all those who are present here too. Because when you're talking about rights of men, because we've discussed, there are a few terms which have been rhetoric in our conversations. Domestic violence is one. The misuse of laws is another. The misuse of dowry laws is again, I can add to it. Rights of men, rights of women, harassment of men, harassment of women. There are few terms that we've tried to refer to time and again. And when we talk about the misuse of dowry laws in relation to rights of men, I wish to come clear on this fact that when we are going to talk about rights of men or rights of women, it is not trying to demean the component, or it is not trying to demean the right of the other party which is involved. So if we are going to try and talk about the rights of men, no ways this dialogue or this conversation that I'm going to have is the beginning of demeaning the rights of women in relation to what stand they hold in society or what stand they should hold in society. The only point is that if we look at the journey that the anti-dowry laws have, they've traveled so far in the history. In the middle of the debate that started with 1961, we have a act which is somehow not that legally sound that it should have been when it defines what dowry is and under what circumstances, because it's a debate in itself. So I'm trying to be very specific of I'm trying to be as precise as I can be. When we look at the or the misuse of dowry laws, one, there is no significant or no comprehensive definition of dowry that we can define. We, under section 2, under section 3 of the Dowry Prohibition Act 1961, we have the outlines of the dowry, whatever the act says. But we have a dire requirement to look into the revamping of this particular structure that we've created in this form of act, because somehow rather than taking care of the dowry deaths, this act has created a legal terrorism. It is a very strong term that I'm trying to refer here, but it cannot be undermined that Dowry Prohibition Act 1961 has created within itself a scope of legal terrorism where this intention of vengeance has crept in. So rather than creating justice, because Professor Dadich was absolutely right when he said that it is not about the right of men, or rather, I would add to it, it is not about the right of women, it is about the component of justice that has to be delivered. So when you talk about the legal terrorism that this act has initiated or this act has created, there is a plethora of statistics that I can narrate. I can narrate the crime bureau's the statistics which says that the number of suicide of married men is more than married women. And then there is going to be a counter attack for the same, that when you talk about the rights of women, there is going to be more of the harassment that they faced. But when you talk about harassment, the latest data also says that the violence that men have faced is increasing. So from 4% to 17% to a 26% data, where now even the apex court is trying to acknowledge the fact that yes, violence is not gender specific now. It is not gender specific, and it has been amply made clear by in Sanjay Yadav versus Anita Yadav, where the court at least acknowledges the fact that yes, the component of violence within marriage can come from the side of the women as well. So when you're trying to create a discourse about this legal terrorism, we have to understand that it is not going to be only the implication that is going to be, restricted to the legal domain itself. That is going to trickle down. It has already trickled down to different aspects. There's a psychological aspect which is involved. There's a cultural aspect which is involved, and there's a social aspect which is involved. So when you talk about society, suddenly this taboo which should have been actually associated with dowry, is it gets associated with the family where such a complaint gets talked, or it is alleged that this is happening. From that social aspect to the denouncing, or to creating a social taboo, or to the different stigmas which are attached, there are so many psychological factors which get involved, starting from suicide to loss of esteem to the loss of privacy, specifically in relation to the family on whom the allegation is being made. Because I am not going to get into the nitty-gritties that in majority of the cases these allegations are true, because if you look at the reports that we have with us, out of the 80% cases that are filed in case of dowry allegation or dowry harassment, there has only been a 15% acquittal rate which is going on. And that acquittal rate has considerably come down after 2015, because since 2014, the Honorable Apex Court has started taking a different stand in relation to how the cases have to be handled. A viewpoint has already been given by Professor Darij. I'll try and take it forward. But before that, when you talk about the psychological impact which is coming down on these families, the scope of 498A and the scope of 304B of IPC, in collaboration with the 113B of the Evidence Act, they try and create this structure where not only the husband but the immediate family members also get become the conspirators between the whole domain. And when you talk about this family, there are certain social obligations which are attached with the family. It can be because of it can be because of the old age of the parents. It can be the dependency of the parent on that male against whom the allegations have been made. It can be because of the dependency of the children on the father. It can be a number of reasons where the social stigma also tries and eats away a lot of space for this male counterpart against whom this component is being raised. If we shift our consonants towards the legal implication that is created, there are so many rights, or there are rather, I would rather use the word injury. There are so many injuries, legal injuries that can be created against men wherever the misuse of dowry laws can take place. So you have, starting from criminal conspiracy to false evidence being instigated, specifically to people who are in, who are occupying public positions or places of public authority. They also get, hugely, or they can be hugely implicated, because this, the word that I'm using here has various connotations, but when you look at it, there is a legal blackmail that gets attached to 498A, even though 498 specifically does not mention the word dowry. A lot can be covered under the scope of cruelty. Are we talking about physical cruelty? Are we talking about mental cruelty? Are we talking about economic cruelty? So a lot can be attached to the word or the component of cruelty. And the scope of, when it gets, or it gets read with, specifically with 113B of the Evidence Act, this scope of 7 year, this 7 year journey can make or break the psyche of the person. So it is not only intended that we have the female the or the female one party becoming strong or becoming revengeful. We have cases like Jasbir Kaur of versus State of Haryana, and we have Kana Raj versus State of Punjab, where the high courts have been very vocal about the fact that it can be the cruelty can come from the side of the women as well. We've acknowledged this fact. We've acknowledged this fact that every single family member may not directly be involved. But when you look at the implications of 498A, it's just that now we've shifted the stance to that too. Thankfully, after 2014, when the Apex Court has changed the stand on that, the implication from social stigma, where I'm not even trying to get into, because we have personals talking about that topic as well. Getting into hindrances which are caused by the police department, or the harassment or blackmail, or the loss of reputation or loss of money being involved within that scope, because it is definitely going to be covered under the scope itself. But when you look at the social implications and the psychological implications and the legal implications, we cannot deny that yes, the community that or within that scope of marriage or the institution is you know um, is not actually having the balance of power with them. It is not contended, it is not denied that there are cases where dowry, because now dowry deaths have come down to the scope of within even lesser than 10% in certain cases. I am not ignoring the fact that the cases of dowry harassment can go unreported. I'm not ignoring the fact that there are the cruelty still exists in the name of that. The only contention that I would like to bring in is that there are a number of reasons which the blogs or the the initiators would give in, that there can be marital discord, there can be disagreement, everything that can provoke the women to create this arena of vengeance against men. But on the same side, we cannot ignore the the scope of bringing the positivist schools, the school of thought for jurisprudence, and again the positive school of thought for criminal or criminology or criminal law itself. We need to understand that not only the scope definition of the act needs to be revised, because we need to bring up a very strict structure of you know parameters to be involved within the scope of dowry. The act is silent on so many facts. Act is silent, act promotes stridhan. It says that it is the right of women to have or talk about their stridhan, but on the same side we do not have strict prohibitions about what sort of gifts are involved wherever dowry is concerned, because the act talks about the willful acknowledgement of gifts being given by the bride's family. We have on one structure, we have the parameters outlined that not more than 11 people can be a part of the marriage brigade or the possession, or there is this little amount of money that has been stored, or that has been mentioned, that within the scope of money, nobody has to be forced to go out of their way. The girl's family doesn't have to be forced. But what connects this force with cruelty, how it is going to be covered under the scope of cruelty? We need, because there is going to be so many hiccups wherever the investigation is going to go on. But then we have to be very clear in terms of law. At least that scope of structure has to be developed. That structure has to be, that has to be laid down. That structure has to be detailed out, that within this structure, dowry exists. Within this structure is what is going to be considered a gift. Otherwise, this dilemma of me affording this gift and being being willful in handing it over to my daughter is never going to be differentiated from the forceful dowry that is going to be demanded. And sadly, this time limit is not going to get restricted to 7 years. So this cruelty can go beyond 7 years. This blackmail on both sides for 7 years is like, for those for 7 years, there's a lot of blackmail that goes on. But at the same time, this cruelty can go beyond 7 years. There is no scope or there is no limitation that for after 7 years there cannot be a natural death or there cannot be cruelty involved. So there are so many points that we need to discuss, and we need to restructure. There has to be a very, constructive and liberal thought, a deliberated thought that has to go behind this reconstruction of the act. Otherwise, what we are going to do is, um, this gender gap that already exists in the society, this gap where one segment of the society is direly against the patriarchy that exists, or the segment of patriarchy that is direly against the scope of freedom for women that exists. This balance is going to create a very defective society where we're going to bring up our kids. So for the sake of not only the men, I would request that when you're going to talk about men, we need to reconsider the fact that children are also involved. It is not going to be a productive, positive society for anyone to live in. So when we are talking about the misuse, we have to take care of the fact that this misuse is going to be this misuse has to be rethought. It has to be reconstructed. Otherwise, this scope of harassment, the scope of blackmail, or the scope of loss of life is not only going to be restricted to this particular act itself. It is going to trickle down to harassment also, because our workplaces are not gender neutral in terms of harassment. uh, our our workspaces, our homes are not gender specific, are not gender neutral in terms of violence. We are not gender neutral in terms of pain. We are not gender neutral in terms of bullying. We are not gender neutral in terms of narratives that we have to talk. It is going to be both ways, because when we look into these cases, wherever we are referring to matrimonial disputes specifically under the legal aid, we come across every sort of dilemma. And that dilemma, again, is not gender specific. It is gender neutral. We have men crying for help. We have women at the same side of the story. We have women who are crying out for help. But my only initiation is that bravo to the organizing team for at least creating this narrative where we can talk openly about the rights of men being hampered, or the rights of men at least being acknowledged. Because the constitution also talks about the specific categories of vulnerable groups that need to be addressed. And wherever these laws are concerned, this legal terrorism, this little mafia that we've created, the mafia, has to be broken down so that the real essence for which the act, the Dowry Prohibition Act, was created should at least live its life. We need to rethink this discourse so that the actual objective with which this act was created in 1961, at least some component of that can be achieved. So thank you so much for sharing this stage with me for this dialogue. And I'll be ever obliged to the organizing team for making me a part of this. So thank you, Deepak, and thank you to all the dignitaries who are present here.